Good morning, everyone, and welcome to the New South Wales Community of Policy Professionals webinar series. I'm Louisa Mamooney, and as host of this meeting today, I would like to acknowledge the traditional owners of the lands on which we're meeting. I'm on Gadigal land, and I recognise the lands on which you are on today, also as Aboriginal land. And also acknowledge the tough time that has been experienced recently with the voice for Aboriginal people and for our broader community as well. Today we are joined by Richard Hurford and Shakira Harrison. I'll just give a little bit of an intro to our speakers, and then I will pass over to them for the presentation and questions afterwards. So Richard Hurford is Deputy Parliamentary Counsel. He joined Parliamentary Counsel's office in 1997. So we're very lucky to have someone so experienced joining us. And in addition to standard drafting work, which I'm sure, Richard, there isn't such a thing as standard drafting work, but please tell us more about that. You also administer Parliamentary Counsel officers, work with crossbenchers and the opposition members of Parliament. Shakira Harrison is an Assistant Parliamentary Counsel. She joined Parliamentary Counsel's office in 2020 as a legal graduate, and she loved it so much that she decided to join. I will call it the firm, and has also worked in other external law firms, and she chairs Parliamentary Counsel officers, learning and development committees as well. So very welcome to you, Richard and Shakira. I will pass over to you now for your presentation, and for our audience, there'll be plenty of times for your questions at the end, and hopefully we'll get a good discussion. So when we come to that time, I'll put some more instructions in the chat about how to get involved with that. So thanks very much, Richard. Over to you.
Okay, thank you very much, Louisa. I'll just share my screen so I have some slides to talk to, and then we'll go from there. Hopefully everyone can see. Are you seeing that, Louise?
Yes, that's excellent.
Excellent, good. Now, welcome everyone, and thanks for coming along to listen to about the strange and obscure and weird world of New South Wales PCO and legislative drafting. Just want to say in advance that unlike a lot of other lawyers, we are not frustrated actors, and so public speaking is not our special skill. So I'm going to treat this presentation as a discussion. I'm going to pretend I'm just chatting with Louisa, and if anyone wants to interrupt and send in a question and have Louisa interrupt me, I'd really enjoy that, because it's much better than the alternative. But I'm here to tell you about New South Wales PCO and also a bit about legislative drafting. So we're going to have a quick chat about the history and the people of PCO, what we do and who we are. And then we're going to talk about what drafting is and our other role of providing access to legislation. And specifically on that, Shakira is going to demonstrate our whiz-bang website, which we think is not only the best in Australia, but is in the best in the world. And we have international conferences. In fact, we just had one a couple of months ago where we had everyone from around the Commonwealth, and we think we're the best in the business. So hopefully you'll enjoy our webpage too if you don't already know it. So let's jump in. Who are we? Well, what do we do? We are the PCO, the Parliamentary Counsel's Office. And the simplest way to describe what we do is that we write the written law of New South Wales. So not the judge-made law, the written law made by Parliament or delegated legislation. So as you can see there, that includes all bills that go to the New South Wales Parliament. That's the government bills, but also the private members' bills. We also draft amendments to the bills as they're going through Parliament, and we do that for the government, and we do that for the opposition and the crossbench as well. We also have the function of drafting all the subordinate legislation, the regulations that go to the Governor in Executive Council. And so that's every regulation. There are also a bunch of other instruments that we write as well, Sometimes they're ministers' orders and threatened species notices under biodiversity conservation. The rule of thumb is if it's going to be done by the governor, then we generally will want to be involved. If it's some sort of other rule or instrument by a minister or authority or board, we try not to get involved because otherwise we'd be writing everything. And there's only a few of us here. The next thing we do is environmental planning instruments under the Environmental Planning and Assessment Act. We're the only state where the PCO drafts the EPIs. It was asked of us, I think, in the 1980s or the 1990s, maybe even earlier, and it's a huge part of our work. And so every SEP, State Environmental Planning Policy, and also local council LEP comes through us from DPI. So that chews up quite a lot of our work. And we have a couple of programs got listed there, the Staged Repeal program. Some of you might know that regulations have a sunset clause. Generally, it's 5 years, but it can be postponed by order 5 times, or, you know, an Act of Parliament can postpone it a bit further. These all came in various states around Australia, these staged repeal of regulation programs in the late 70s, early 80s, because regulations, there were some around that were from the 1920s and 1930s. And so they were very old, they were very hard to understand. And for the sake of the user and clear legislation, but also for the sake of democracy, that these were subordinate instruments that no one alive had looked at. It was decided they all needed to be repealed and remade, and it should happen regularly. So that's the side of we write the written law. It can be quite a large program. In some years, we can do up to 8, 9, 10,000 pages of law. It hasn't been so big in the last couple of years for a couple of reasons, COVID, new governments, and things like that. But we churn out pages and pages and pages of primary legislation and subordinate legislation. And so then the other side is the people need to know what the legislation is. So we provide the access to legislation. Everything we write goes up on our website, legislation.nsw.gov.au. Shakira will be talking about that later. But hopefully you guys have seen it, that you don't use Austlii, you come straight to us. Austlii gets its information from us, so we're the trusted source. So I hope you see what we provide and have a good experience when you get there. Who are we? Well, we're a small executive agency. We're within the now Cabinet Office cluster, the old DPC. There are about 50 of us, a bit less now, and about half are lawyers. But we have editors and publishers to check our work and help us publish it onto the web. And we have a small IT team to keep that web page and all our specialist drafting software up and running. And being an agency, we have all the sort of executive and corporate support staff that a small agency would have to keep us compliant with all the government rules. One more thing to know about us is that we are part of a club of Parliamentary Council's offices in Australia and New Zealand. It's called PCC, New South Parliamentary Council's Committee. And it's the PCC that drafts the cooperative legislation. When a project, you know, at the old Premier's Conference or the COAG and now the National Cabinet decides, oh, there should be a national defamation law, it might then get delegated down to the Standing Committee of Attorney Generals, and then they will ask PCC, and then one state will volunteer to draft it. So we don't only draft legislation for New South Wales. We're often part of cooperative projects of drafting legislation for the whole of Australia, and each state takes its turn, but as we're one of the larger states, we tend to do more than other states in that sort of work. And we've been the secretary of that committee forever, 20, 30 years. History of us. What sort of people, what's the story behind the PCO? Well, if you go right back to colonial times, in 1823, I believe is when there was some British legislation that established a legislative council to help the New South Wales governor govern the colony, and there was an Attorney General, and the Attorney General drafted his own legislation in those days. And for the next few years, that's how it worked. In 1856 is when the colony got a proper parliament, and legislation, with two houses, the upper and the lower house, legislation from then on was drafted by lawyers on a fee-for-service basis. So either the Attorney General or the Attorney General would go out and find a lawyer to draft something for them. It was in 1878 that the government of New South Wales first appointed a parliamentary draftsman, Alexander Oliver. It's actually quite early because Britain, the Westminster Parliament, only appointed their first parliamentary draftsman in 1870. So the colony of New South Wales was following on pretty quickly on the bureaucratic structures of the British Empire. In 1970, the title was changed to Parliamentary Counsel, make it less sexist, but it wasn't until 2018 that a woman was appointed as Parliamentary Counsel, and that's Annette O'Callaghan, who's the Parliamentary Counsel today. She's our boss down the corridor. What is legislative drafting? Well, it's a specialty, and we think it's something that should be drafted by specialists. People who need an understanding of all of government and how Parliament works and have a whole of government perspective. That we have a lot of legislative drafting conventions that we follow around Australia and around the Commonwealth that we keep consistent with, that we have a holistic view of the statute book. We're one of the few groups of people who are constantly reading different acts of Parliament. And we're also independent from all the other government departments. You'll see that little snippet on the side of a story from the Financial Review. From time to time, governments try to outsource the work of a parliamentary drafter. That one talks about when Federal Treasury tried to outsource some tax laws. And it usually ends in disaster for two reasons. One is the private sector lawyers don't really have an understanding of all those things and the bullet points in the right. But the other thing is it's very, very expensive. They don't pay as much. They definitely don't pay as much as one of the big four law firms. So it usually comes back in, even if it's gone out. Who do we work for? Who are our stakeholders? Well, in our main job in drafting bills for the government, for Parliament, we say our client is the Crown. And by that we mean the Crown as permeated to us through Cabinet and the ministers. We get instructed by government departments and agencies, but in our mind, they are acting as agents for the Crown. Other times we do work for Parliament and its committees. And when the last bullet point, we work for members of Parliament, that is because we do non-government drafting as well, which I'll come to in a minute. On the publishing side, we have clients as well. Of course, the people who give us instructions, they want their legislation up and published so that their stakeholders and their ministers and their people can see it straight away. But we also engage quite proactively with the courts and the legal profession. We have committees of engagement with the Supreme Court, the District Court, and also the Bar and the Law Society, where we get together and discuss what they think of our website, how it can help them, how it could be more useful in court. They also sometimes comment on our drafting styles, and we then explain why they are the way they are, and we comment on their rules, and it's often quite an interesting exchange. And of course, on the publishing side, our biggest stakeholder is the public. We draft in plain English on the basis that any citizen of New South Wales should be able to pick up the law, read it and understand it. And then, of course, we have partners with the Parliamentary Council's committee who, we have to draft in styles that are consistent across the country when we're drafting cooperative laws. I'll just digress now and talk a bit about the non-government drafting program, because that's my program. That's the program I lead in the office. Generally, the basic rule is that we are lawyers and public servants for the executive. We're not part of Parliament, we're part of the public service, and we work for the ministers. But around the country and around the Commonwealth in Westminster systems, more and more Parliamentary Council's officers have been helping the opposition and the crossbench do private members' bills and also amend government bills as they're going through Parliament. In New South Wales, it started when Premier Nick Reiner had an unsuccessful election, and I think it was around 1990. No, I can't year here, but it was he was in minority and he had to do a memorandum of understanding and cooperation with 3 independent members, including Clover Moore and Peter McDonald and John Hatton. And one of the topics of the memorandum of understanding was that the services of Parliamentary Counsel's Office would be provided to the opposition and the non-government, so that they could help provide the best private members' bills that they could. Until that time, they would have just, I think, gone out and either done it themselves, got friends who were lawyers to draft bills. They would have asked the clerks to help, and sometimes the clerks were lawyers and sometimes the clerks weren't. So they were really aching to have some non-government, to have some Parliamentary Council help. And since then, the program's got bigger and bigger because there have been more and more non-government crossbenchers elected, and the government has been in minority more and more over the years. The basic rule is that we provide every 6 months 250 hours of drafting time to the opposition, and every other member gets 25 hours each. We keep a record of how much time they're using, and sometimes people use up their time. We never really cut them off because it's a democracy and we feel they need our help, but sometimes we would say to them, do you really think you want this bill? Because it will use up all your time, and then that sort of focuses the mind and we can sort of negotiate what sort of work we can do for them. Just as a example of what's been going on in non-government program in the last couple of weeks. So, we're in the unusual situation of the government being a minority in the lower house and the upper house. And so in the Legislative Assembly in the last couple of weeks, Helen Dalton, the independent, introduced a Water Management Act bill. Gareth Ward introduced a bill about ministerial diary disclosure. There was a big debate prompted by a National Party member about the Rural Fire Services assets, the Red Fleet, because local councils have to depreciate them, and they don't want to do it anymore. They want the government to pay the money, and that's kicking along and get everyone excited. In the upper house, in the Legislative Council, we had Emma Hurst from the Animal Justice Party introduce a bill about the Surveillance Devices Act, because I think there's been some prosecutions of people going in and filming, piggeries and places like that. And Abigail Boyd from the Greens introduced a bill about prevention of cruelty to animals to try and establish an independent office of animal welfare. So, interesting topics from the opposition, from the crossbench side. And when I started 25 years ago, we were doing this work, but we could assume that even if it was introduced, it probably wouldn't be debated, and even if it was debated, it wouldn't be accepted, and it wouldn't pass one house, and even if it passed one house, it wouldn't pass the other. So, but in the last 8 years, bills are now not only getting introduced and debated and passing one house. In the last Parliament, 6 bills passed both houses. Some were Greens, some were Labor, some were other independent. So more and more non-government bills can pass and be assented and become law of New South Wales. More than that, also, that often a private member's bill is sort of kept in the back pocket by a member of Parliament, and when a government bill on the same topic is going through, we repurpose it as an amendment in committee, and the government might accept it then. So we've got to treat this program as strictly as we treat government drafting, and not treat it. Half the time, a private member's bill is a political document. It's a statement by a member of Parliament what they see their policy to be, not a strict legislative document. But the other half the time, they want this to be the new legislation of the state. So it's a balance of how much work you do. But the other thing is we get instructed directly from the member of Parliament or their staffer, and they have no backup of government departments. So we're often drafting based on one-line emails saying, I'd like a law to do blah. And so it means the drafter becomes the policy officer at the same time. Anyway, that's my little digression into non-government drafting. Back to the main thrust of the talk. We have our New South Wales legislation webpage. Shakira is going to give you a spin around that. We think it's great. I hope you think it's great too. We spend a lot of time dealing with IT and discussing it with other states about what they're doing. We try to be one step ahead of each other state when we meet together to say our website's better than yours, and we all think we're better than the Commonwealth. So let's switch gears and now talk about what does a drafter do. This was a quote from Professor Crabb, who was a parliamentary drafter in Ghana at an international conference. A drafter is an architect of social structures, an expert in the design of frameworks of collaboration for all kinds of purposes, a specialist in the high art of speaking to the future, knowing when and how to try and bind it and when not to try. Thus, those who seek to practice the art of a parliamentary counsel should be persons genuinely interested in legislative drafting, with every likelihood of making legislative drafting a career. Well, that's very flowery, but I think there's a couple of points in there that I take away. One is that it's a job that you should make a career. Most parliamentary drafters around the world have been in their jobs for 5, 10, 20 years. It's a specialty that you can't jump from field to field. Another way to say that is a drafter is a lawyer who provides a specialist form of legal services to ministers and other members of Parliament. It's not like other practice of law. We are not solicitors, we are not barristers, we're something different. And once you're here, it's very hard to leave because the skills you've developed are not the skills that other people need, but they are special skills that everyone needs to have in a jurisdiction. Like I said, we're a lawyer, so that when we're dealing with governments and departments and instructing officers, our relationship between us and our instructing officer is that of a legal practitioner and a client. I think that's non-controversial, but a decade or so ago, someone took a point to the federal court to say that Parliamentary Counsel are not doing legal work, and a federal court judge accepted the argument and said we weren't covered by legal professional privilege. But luckily that went on appeal, and the full bench of the federal court overturned the lower court and said, yes, we are lawyers and we are providing legal services. So that's good to know. We're specialist legal professionals, and we're bound by legal professional privilege. We provide legislative advice and drafting services in a professional and impartial way. So in the same way that a lawyer doesn't just do as they're told, they have all sorts of other ethical obligations to the courts and to the community. We have ethical obligations to as legal professionals, and we're also bound. We're public servants, so we're bound by the Code of Practice and all the codes that apply to us under Public Sector Management Act. It is not the role of a drafter to blindly accept whatever an instructing officer wants. Now, I've got lots of friends who are instructing officers, and they always chafe when Parliamentary Counsel pushes back and says, it's not your role. And in fact, it is our role, and it has been since time immemorial. Because we have special skills, and we've done this across the statute book in many ways. We've collected knowledge, skills and experience that our client, the Crown, appreciates and expects us to use to challenge what instructing officers are telling us. We are meant to challenge, scenario test, ring a bell when we think something is unusual, and push back and escalate up inside government departments all the way to the minister's office to say, we don't think this is really what they want. We are not stenographers. We do not just type away what someone tells us. We are meant to use our minds, our skills, our experiences to produce the product, which the legislation, and make sure it's the highest standard possible for the benefit of the people in New South Wales. Drafting requires hard work, devotion, attention, and an ability to communicate policy in an understandable and user-friendly way. Another way to say that is we strictly follow plain English rules and policies. We were one of the first places in the world as legislative drafters to follow the moves coming out of the UK and America for rewriting legal documents in plain English. And then we've developed, in conjunction with our interstate colleagues and our colleagues around the Commonwealth, legislative rules for what plain English drafting is. You know, we hope that now any member of the public can generally pick up a modern Act of Parliament and understand it and not require too much assistance from the legal profession. And if it's simple things, you know, they should be able to work it out themselves from the Act of Parliament. And so that means that the drafter plays a major role in the form and content of the legislation. And I think that's why a lot of us stay here many, many years, because it is an exciting job, because you are there at the coalface of a changing society. I think if I go back to the quote from Professor Crabb, there was the bit there that it's talk about we are speaking to the future. And I meet people and I tell them what I do, and some people say, God, that must be the most boring job in the world. But some people are interested. And the answer is, why is it interesting? It's because you're dealing with a society that's constantly changing, and then therefore we need our rules to keep up with it. Our technology is changing, so hence we work on things about self-driving cars and new technologies of you know, social media and gig economy platforms and things like that. But we're also dealing with all the social changes. In the last couple of years, we've had the private members' bills, the conscience votes on voluntary assisted dying and, you know, abortion law reform. And if there's something that's interesting and controversial that's going on in the world around us, it normally has to be reflected in the laws of the state. And being a parliamentary drafter means that you are part of that, part of the society grappling with the changes that are going on around them. Now, I think I've used up my 25 minutes, and I feel I've probably bored you enough. And so, Louisa, I'll hand it back, and hopefully we'll hand over to Shakira.
Yes, that would be great. Thanks,
I'll
Shakira.
just share my screen now.
Yes, we can see that.
Oh, great. Okay, I'll try and keep my scrolling nice and smooth, but let me know if that's not coming across. This is obviously the New South Wales legislation website that Richard mentioned. We provide the public and government with access to legislation by maintaining this site. It was launched in 2002, and it's established actually under the Interpretation Act as the official New South Wales government site for the authorised online publication of legislation and the Government Gazette, which you might publish notices in. The collections include in-force and repealed legislation. Within that, you can access point-in-time historical versions, which I will show you shortly. And we have an as-made collection. So each original instrument as it's published can be accessed there. For example, an amending instrument, once it makes its amendments, won't be in force anymore. You can access it in as made. You can also set up a favorites list if you come to this website frequently. And this notice board contains some interesting information For the week, you can see the most frequently accessed titles, and you can read about new and enhanced features when using this website here. It's updated with links to officially notified statutory instruments and information about bills. We also have a note here about the launch of our standard, which is a really long document, so I'm not going to open it, but it's a helpful guide to the sort of rules and approaches that we use when drafting. It includes some really helpful appendices. One of them is about the kind of plain language that we use. And so there's certain words that we might have used in the past, like heretofore, that we don't use anymore. And it will show you the corresponding simplification that we would use today. The notification page contains that list for the week, for weeks of instruments that have been notified. So for last week, you can see the regulations, the planning instruments that have been published. The information page is also a really helpful page when you're first coming to this website, with a bit of information again about that standard. And I think I saw a question pop up about, if there's guides, there's a guide to non-government drafting that Richard mentioned, information about notification and how these different things work. So that's a really helpful page. I'll now take you to an in-force act to show you some of the functionality of the site. So I'll take you to the Child Protection Working with Children Act. And the first page that you'll land on is this status information page. And this gives you a nice overview of where this act is at. All of its provisions have commenced, but you can see that there are amendments proposed in other pieces of legislation that haven't commenced. And you can see who's responsible for administering this act, and that note that, this is the official version of this act. Navigating on this contents page, which you can drag, I hope that's presenting smoothly, as you'd like. You can collapse, so see each part and get a sort of high-level view of what this act does. And then you can expand. You can view an individual section, or you can view a whole part. And within this, once you've read part 1 and you want to go to part 2, just click that arrow and it will add that part to your view. At the top, there's a banner. Statutory instruments will show you the instruments, the subordinate legislation made under this act. And the key resource that we use a lot is legislative history. So legislative history allows you to view the table of versions. So each time the act is amended, there'll be a new version published. You've got your original act, and at the bottom, you can also access that in PDF if there was an explanatory note. Sometimes that's here, but you can, under bills, you can get that link. And of course, you can go on the New South Wales Parliament website and go very far back and access explanatory notes and things like that. Amending legislation is going to show you everything that's amended this act. And just as an example, this is a really helpful overview of when this act commenced. But sometimes this can actually get quite complex by way of comparison. This is another act dealing with similar subject matter. But here you can see that this act had a very different kind of commencement. So that's why this original legislation tab can be really helpful to get an idea of when there are actually parts of this act that haven't commenced. So that's why that's really helpful tab. And history notes is what we use. If you're not familiar with what these terms mean, what does AM mean? This little key button will take you to a list of what these abbreviations mean. So AM means amended. So you can see that Section 3 was amended by this instrument, so Act number 31 of 2013, by this part of that Act, an item 1 in Schedule 1, and then it was later amended in 2019 by Act number 25. So when you read that, for example, we can see Section 8 was amended most recently by 2015 number 29. You go to that list of amending legislation and you find 2015 number 29, and you open that up. And it was going back to Section 8. It was Schedule 2, Item 4. Schedule 2, Item 4. And we can see that the change it made was to Section 8, and it inserted a new paragraph. So when we go to Section 8, and we see that new paragraph, we get the context and we see that, oh, this is about creating another defence to proceedings, and this paragraph was inserted by this amending act. So that's what that tab is for giving you that bit by bit view of when every change was made, which is really, really helpful. And when you're within the provision itself, at the top here, you can turn history notes on and off. So I've got them turned on. And so it's copy and cross that information from that list that we saw, that this section was amended in 2015 by Act number 29, Schedule 2.4. And one of the key website features, the timeline, which you see along here, go back to the beginning. It allows you, using that list of history notes and amending legislation, this sort of puts it together for you. It allows you to generate side-by-side comparisons. So when you click this, I want to see what change was made on the 1st of September. This disclaimer is just letting you know that this comparison is, for information purposes. It's not necessarily something that you can absolutely be guaranteed. It's technology. So that's just our legal disclaimer about using this. You can view these comparisons in different ways. I like to drag the contents across so I get a nice big view. Inline differences is the default, but I like to see side by side that Act September 2022 and today. And I like shaded changes. The color makes it really easy to see. And I can see that the changes made were to change a section reference. So for some reason it was 36, and it's obviously been updated to 34. So not a lot happened then, but to really see how this tool works, I go back and I want to compare against an older version and see what changes were made. I can see that some more significant changes were made then. I can see that, a new paragraph has been inserted here. I can see that this whole section has, so red is an omission, green is an addition. I can see that, this section has had some really significant changes made to it. It's been almost rewritten. And I could jump, to the very last page, very last change, and it's just the history notes, but I can see here another paragraph was inserted here. You can see that this reference to the Prevention of Cruelty to Animals Act has had to be updated to include some other provisions. So that's the benefit of this view. It gives you that that high level look at how things have changed at different points in time, which can be really helpful. And just as a final feature, we use search quite a lot. It's one of the best ways to start a project. We don't like to necessarily reinvent the wheel when, we want to see how things are done across the statute book and achieve consistency. So I'll just show you some basics of using this page. I'm in the planning team at the moment, so I'm drafting exclusively planning instruments for 6 months. And there's a lot of terminology that springs up. And for example, I recently needed to draft a provision that related to mansard roofs. And I recalled that I'd recently defined it somewhere. So here I can just search for mansard roof. And I know that I defined it. So I'm looking for a defined term. If I click that search and I press this button, which is show hits, I can see that this is where I defined it. And if I click on that, it's going to bring up exactly where I put that definition. So I can, that's my starting point. If the same definition applies, it's great to use the same definition. If for some reason we mean mansard roofs in this LGA slightly differently, then we would perhaps define it differently. And one of the benefits of this as well is that you can decide, well, I just wanted to see how I've dealt with something recently. Our approach to, this is a planning term, BASIC's targets, has changed recently. And I can see that, search. I can see that this year we've only dealt with it in 2 instruments, and I'll go to those 2 instruments as the most recent examples of where this term has sprung up and see how they've dealt with it. And I can see that these are principal LEPs, we call them. They're not amending instruments. So that's a good place to go to, that in 2023, when we wrote this LEP, how have we spoken about BASIC's targets there? Menu assisted is really helpful when you want to do what is a Boolean search, because you're not sure exactly how something is expressed, or you anticipate that there's going to be variation in how it's been dealt with in different pieces of legislation. So if you want to find references to, just clear my search. You want to find references to, for example, an onus or burden of proof, and you know that maybe it's called burden somewhere, maybe it's proving, not proved, or proof, and you know that there's going to be variations in how this is expressed. I might search for the word onus or burden within 10 words of proof, or it could be proving or proved or proven. So I'll put a question mark after V, which would be the last letter. And you're using your order of operations from high school. So because there's 2 alternatives, I put a little bracket here. And if I search that, I'm going to have, how many results are coming up? 123 results. When I click this show hits button, I can see here that there's a provision about the legal burden of proving the elements of the offence. Here it's expressed as the onus of proving the exception. Here it's expressed as onus of proof, the onus. Yeah, so it's going to give you all of those different hits. The legal burden of proving. That's how you cast your net nice and wide. Another common example is where something is a provision about looking for someone to have particular knowledge or experience or skills or qualifications. You can imagine that's expressed differently, and you'll want to look at some examples because you want to, maybe look at the context of how it's been dealt with in relation to different professions or different schemes or different bodies, and see what's out there. You could do a search for skill, but it could be skills. So you put a question mark to count. Sorry?
Shakira, we have 15 minutes left, and I have a load of questions waiting for you and Richard. I think we should move to the questions now. If that's okay with you. I was
That was
hesitant
the last
to
thing I was gonna
interrupt
show anyway.
because it was very useful. I think I did not realise how many bells and whistles you've added to your website recently. So that's fantastic to have the walkthrough and how to use it most effectively. I'm going to turn to the questions, and I have listed the order in the chat. So Andrew Road, you're up first. Please turn your camera on and introduce yourself for all our audience so we know who you are.
Thanks, Lisa, and hi, Richard and Shakira. I'm Andrew Road. I'm in the Department of Planning and Environment, and I work in the biodiversity policy space. I just had a question about timeframes for legislative drafting. Wondering if you can provide some typical timeframes the PCO needs to draft different types of legislation, or so making whole new acts, revising acts, amending acts, creating new regs, amending regs.
That's a great question. The simple answer is as much time as you can give us, because you know, we always get asked, and our answer is how long is a piece of string. We unfortunately have parliamentary deadlines, and our masters are working to a media cycle, and things are just rapid. And our feeling is that the process is faster in New South Wales than it is in other states. I once visited a British drafter, and they said, "Oh, if you're going to rewrite a whole act, you've got to have 4 years to do it." And you know, we never get that much time here. And we can be given the proper process is the department and the minister prepare a cabinet submission. Cabinet agrees that a bill needs to go to Parliament, and then instructions come to us, and we draft the bill, and then either full cabinet or a subcommittee approve the introduction. You know, that's the beautiful theory. It's often truncated due to urgency for good reasons, COVID, terrorism, but also just the minister wants his bill on Monday, and so we just have to draft all weekend. And it's often, the time taken often does not reflect the length of the document that comes out. You know, a 1-page bill can take longer than a 40-page bill. And I think we've had some statistics done that drafting is between the instructing officer and the drafter, and then the client ministers, is an iterative process. Draft follows draft, instructions, draft, instructions, draft. And the average is about 15 drafts for a bill that goes into Parliament. But there can be some that take a number of years, and you get up to 50 or 60 drafts. Sometimes a big bill is easier to do. I just did a building bill that's about 50 pages because the policy was clear and thought out. It was easier. We got it done in a couple of months, and it went through Parliament. It was really about an hour in each house debating it. Whereas you can have small 1-page bills that go around and around and around, and they go off for consultation and come back again, and off for consultation and back again. And then when they get to Parliament, every man and his dog wants to do an amendment in committee. And, you know, if it's something that affects ordinary people in everyday life, like libraries or mechanics, you know, every member of Parliament will get up and tell their personal story of going to the library or getting their car fixed and stuff like that. So that's 2 different timeframes, but there is no magic equation that tells you. But it does kind of frustrate us a little bit with planning of projects, that sometimes when they're really long ones, you know, the minister or the department might think, we're going to take 2 years to do this properly. You know, we're going to do all this consultation, we're going to have white papers, we're going to have public inquiries, and then we're going to have 2 weeks for drafting at the end of it. And, you know, we'd rather that there was more time for drafting, because devil is in the detail. It's often where you find the really tricky policy questions, is when you get down to brass tacks and you're saying you can do this, but you can't do that, or the application must have this document, but not this document. just give us as much time as you can and try and build in as much drafting time as you can when you're doing your timeframes. I'm sorry, it's not a magic equation, but that's the story.
I think that's very helpful to give some understanding of, you know, I guess the fine line to walk between having a lot of clarity on what it is that you need and also engaging with PCO to start thinking about some of the issues, and actually think having you enrolled a bit earlier maybe of assistance. Nari, let's turn to your question now. And Richard, feel free to give very short answers because we have lots of questions.
I'm sorry, I'm chewing up the time.
Thanks, Louisa, and thanks, Richard and Shakira. My question is, do you provide templates for drafting instructions? And I guess implicit in that is, what are the key things you need to know?
The short answer, we don't have a template. We've been talking about it, and we, I think one might come out in the next year. Our basic rule is, please just tell us a story. Treat us as your intelligent friend who doesn't know anything about what you do, and tell us your story of what you think is going wrong in the current law and what you think needs to change. Now, some people like spreadsheets, other people just paragraph numbered. It does help, you know, to say it's section 77. That's the problem. The court has said it's section 77, and we ask people not to give us, you know, we think these are the best words, but just tell us as much of the story in plain English prose about what's going wrong. I think short answer. But we'll try and get a template out the next year.
There is a template for planning instruments.
Okay,
great.
Cool. Thank you.
Thank you. And Lou Miller, would you like to come on and ask your question? I'll just give a heads up. It's about appropriations bills.
That's right, Richard. Shakira, thank you so much for your presentation. I work at the New South Wales Treasury as a policy and budget analyst, and every year we collaborate and we provide information for the appropriations bills. I was just wondering, what's your reflection on the process that we go through on a yearly basis, and if from your perspective there are things that we could do better? Thank you.
Thanks, Ludmilla. I actually haven't done an appropriation bill for a long time, so I don't think I have observations at this point. I know that, you know, Mark Cowan, one of the other deputies, you know, had done the last appropriation. Other people have done other ones. Sorry, I don't have an answer today, but I'll try and get something back to Louisa. And but we it's a regular bill that pops up, but I'll try and get some information for you. Sorry about that.
And for everyone else's benefit, appropriations bills are the budget instrument that the government introduces into Parliament to make allocations of budget to different agencies. So it's really quite a very specialised area, really, but fascinating once you get to know it. We have a couple of questions on private members' bills. We'll start off with Rebecca, I think. Yeah.
Hi, I'm Becca, and I'm from the New South Wales Department of Education. So you mentioned the drafter often becomes the policy officer for private members' bills. How much influence do government departments have in guiding and directing the legislation for government bills, e.g. based on evidence-based research?
I would think that, you know, the bulk of bills for Parliament have been generated bottom up from departments and taking you know, executive briefs to their ministers and saying, you know, we think our legislation is not working, we need to reform it this way or that way, and then convincing the minister to take a cabinet submission to cabinet. You know, of course, we live in a democracy, so there are other forms, other ways that ministers make decisions to take processes to cabinet. But I think even if a minister was listening to interest groups and saying we need to reform this particular area of the law, they would use the expertise of their department to say, you know, well, what do you think of this proposal? Do you have views? I think it would be a brave, courageous minister who would write their own cap sub and go off to cabinet. But in the end, the the process is it's Cabinet that authorises the drafting of legislation. So the department doesn't have to be involved, but a minister would necessarily rely on the department as their first source of advice and counsel. Yeah. Yep.
We also have looks like Louisa may have a question, but a question from unknown person in the chat that links to this is, I guess you've talked about private members' bills in terms of the evidence base that you seek, but what is the evidence based standard that you seek from government agencies in drafting? Like, how much work do you like to see has been put into thinking about that problem definition that you mentioned earlier in preparing drafting instructions?
Well, I mean, do we demand evidence before we start drafting? No, we're instructed, you know, by Cabinet, and so we draft to solve the problem. But we interrogate the question, we interrogate the policy, we challenge the instructors, and we escalate to the Minister's office that this doesn't make sense, this is inconsistent with the rest of the Act that it's amending, or that it's is inconsistent with the other parts of the statute book. But they're political animals, and they instruct us, and like, you know, other legal professionals, if we can, we give effect to the wishes of our client. There's not a sort of constitutional bar or anything that an act must make sense. It just has to, you know, for us, it has to be legally clear, you know, so it's not void because of ambiguity, and it has to pass Parliament. There's a couple of exceptions where the High Court is making constitutional law based on implied rights and freedoms, and I'm just thinking about some of the election funding cases where they found third-party campaign expenditure caps invalid because their Parliament had not considered what was the appropriate amount of money. It was more in a sort of an a litigation-based way, is that because of the freedom of political communication, the caps had to be reasonable, appropriate and well adapted, and therefore when it was challenged, the government had to defend that proposition. So they had to come along and say, well, we have evidence that this is reasonable, appropriate and well adapted. Well, actually, in that case, because it was the first time, Parliament and the government had no evidence that the limit was reasonable, appropriate or well adapted. So in effect, it created a rule that said Parliament has to have evidence before they pass a law about political communication. And so we're still working through the ramifications of that. But that's one small area. And within the other plenary areas of law in New South Wales, and so we're not like the Commonwealth where we have topics where we are only allowed to deal with, we can legislate on anything, you know, surfboards, kites, you know, camping, trees, whatever you want. It's pretty unrestricted as long as it's not inconsistent with the Federal Commonwealth Constitution and federal law.
That's a great jump off to our next question from Lisa.
Thanks, Louisa. So my name is Lisa Mackay. I work in Crown Lands in the policy branch. And my question is, when drafting, do you check that the proposed legislation or instrument is compliant with all federal legislation as well as the New South Wales legislation? And how do you, the second part is how do you manage any conflicts?
Well, it's a good question. We have mandatory CLEs, like all lawyers, and we particularly like the Gilbert and Tobin Constitutional Law Conference that happens every February, and we sign up, and it's now much easier because it's online. We don't learn the federal statute book off by heart, so we kind of rely on our instructing officers and who mostly in the past have been legal officers to know where they're standing on the toes of the feds and the feds are standing on their toes. But we are constantly following court cases and reading about federal court cases and high court cases where state laws have been overwhelmed. But it doesn't actually happen that much. You know, we do swim in different waters. The Commonwealth deals with tax and foreign affairs and armed forces, and we're dealing with education and hospitals and schools, and we rely on the knowledge, the specialised knowledge of the state government departments to tell us if there is an issue. But if we are thinking something in the back of our mind, we're thinking of constitutional issues, you know, excise and things. But of course, you know, the High Court can change what an excise means, as we've seen in the last couple of weeks on the electric vehicles. But we do push back and say, have you thought about this? Have you thought about that? You know, have you read that case from last year? What does it mean? It's a learning and development, a constant learning and development process. And how do we resolve it? We have the conversation, and sometimes a government will say, well, let's try it anyway and let's see if it runs. And so that's why Acts of Parliament are sometimes passed and then found invalid by the High Court, because, you know, you want to skirt up to the edge of the cliff and no further, but sometimes you go over. Yeah.
Thank you.
I'm hesitant to say this, but do you have a few more minutes? Because I want, there's one more question that is relevant to what you just said. It's from an unknown user, so I don't know who it is, but I'll read out the question. It's about when your legislation, or whether there's interpretation of your legislation by the courts. You know, how do you approach that situation? What happens next? How do you feel about that?
Well, I've had one or two provisions found invalid by courts, and then I get outraged. You know, the judges have got it wrong, obviously, and you know, something should be done. If it's a statutory interpretation question, often you have the confidence. You know, if Crown Solicitor's Office, who are just in the floors above us, will let us know a case is on, and they'll tell us the outcome. And then between them and the department who's you know, responsible for the legislation, you can have a discussion. And if it's urgent, you know, we can amend a reg or provide a bill that amends the bill in Parliament. If it's just a mere matter of statutory interpretation, and often if we think the courts have got it wrong, that, you know, it was obviously the first interpretation was correct, we say, to avoid doubt, this means this thing. So if you see those words in legislation, to avoid doubt, it usually means, look, we think this is obvious, but you know, some people are arguing, and so to avoid doubt, let's just make it clear. If something's knocked over on constitutional grounds, there's, you know, federal constitutional grounds, there's not much you can do, so you've just got to draft around it. But again, the legislation constitutionally is allocated, and under the state constitution and under various is allocated to the administration of a minister, and then the minister is assisted by a department. So the response is one that comes through the department, but we would want to be part of that, because if it's been an interpretation of legislation, then we're very much involved.
Thank you. And to wrap up the session, I'd like to thank you for sharing your knowledge. It's been so incredible to hear from a rather niche part of government, but obviously very, very critical, and for sharing that great quote from Professor Crabb. I think policy officers and parliamentary legislative drafters share this architect of social structures, an expert in design of consultation, and speak to the future. So I really love that understanding of drafting, and I think it extends to policy as well. For our audience, thank you for joining us today. We should have another webinar coming up in November with the Cabinet Office, so that'll be interesting. And thank you very much for joining us today and for your interest and enthusiasm in policy. Bye for now. Take care.
Thank
Thanks
you.
very much.